Welcome to the Deep Dive. Today, we're undertaking a really high-stakes investigation. We're looking at a topic that, should be settled science, but is instead tied up in this massive constitutional battle, conversion practices. We're going to go deep into the state laws across the U.S. that are trying to ban these efforts, and how those laws are running headfirst into the First Amendment.
That's exactly right. And our mission today is to give you the full picture. We're fusing medical research, these really harrowing survivor testimonies, and some pretty complex legal analyses.
And when we say conversion practices, we're being specific with that term.
Right, you are. It's what the professional organizations call it. We're talking about any attempts to change a person's sexual orientation, that's SOCE, or their gender identity, GICE. We're intentionally using practices, not therapy.
Because it's not therapy.
It's not. The overwhelming medical consensus is that these methods are, well, they're not just non-therapeutic, they're actively harmful.
And the stakes here, they couldn't be higher. We're looking at a critical legal challenge. It's winding its way to the Supreme Court right now.
The case of Chiles v. Salazar.
Exactly. And this is going to force the justices to decide whether a state's duty to, protect public health.
Yeah.
Whether that supersedes a therapist's claim of free speech.
And if these state laws fall, you're looking at nearly 24 state bans potentially collapsing, just overnight.
Okay, so before we even dissect the legal fight, we have to establish what these practices actually are. Where do they come from? When we use that term conversion practices, what's the full scope?
Well, it's an umbrella term, really.
Yeah.
It covers any effort aimed at modifying, suppressing, or even completely eliminating non-heteronormative sexualities or gender identities.
So you might hear different names for it.
Oh, absolutely.
Oh,
These
yeah.
practices might be framed under names like reparative therapy, sexual reorientation therapy, or that older, much more politically charged term.
Ex-gay therapy.
Ex-gay therapy. Exactly. But essentially, if the goal is anything other than acceptance or affirmation of who the person is, it falls under this umbrella.
And what's the underlying premise for the practitioners who still do this? What's the foundational idea that lets them believe they can fix someone's identity?
Well, despite the complete rejection from the scientific community, they're often working from these really outdated psychoanalytic or religious premises.
Mm-hmm.
They operate on the idea that these identities, non-affirming identities, they stem from some kind of impaired development or maybe a foundational trauma that's derailed what they see as normal psychological growth.
So they're looking for a cause.
They're looking for a cause to correct. So, for instance, you hear common theories pointing to things like childhood sexual abuse or deficient caregiver role models.
Like what? What would that look like?
A distant relationship with a parent of the same sex, maybe, or rejection by peers in childhood. The identity, in their view, isn't innate. It's a symptom of a larger correctable flaw.
It really sounds like an attempt to medicalize something that science now just considers a natural human variation. But this whole concept of curing someone, it goes back a lot further than a modern counseling office, doesn't it?
Oh, it absolutely does. It goes way back into the 19th century. And that's what launched this grim history of just horrifying pseudoscientific techniques.
You're talking about things like aversion therapy.
Yes, the earliest and probably the most brutal efforts involved aversion therapy. And the concept was, it was simple and terrifying. You condition the patient to associate their unwanted orientation with just intense physical pain or discomfort.
And what did that actually look like in practice? These sound less like medicine and more like
Torture.
Yeah.
They were. Under medical supervision, mind you, individuals were subjected to these incredibly invasive procedures. We're talking about being given chemicals to induce violent, uncontrollable vomiting.
Oh, wow.
Or being subjected to electric shock, sometimes directly to the genitals, all while they were being shown gay pornography or forced to cross-dress.
The goal was literally to shock the desire out of them.
That was the goal. And historically, the proponents made these huge, unsubstantiated claims. You'd see them boasting cure rates as high as 50%, but none of it was ever documented with any kind of credible scientific method.
It's just astounding that this was ever considered legitimate medicine. So
yeah.
Let's talk about the shift in how the psychological world thought about this. Homosexuality was officially a psychiatric disorder.
Mm-hmm. In the DSM.
Right, by the American Psychiatric Association, the APA, until 1973. So how did the thinking move from electroshock to the kind of talk therapy models we see today?
Well, this is where it gets really, really interesting when you trace the intellectual lineage. Because even after the physical abuses of aversion therapy started to fade, the underlying idea, the pathological model, it persisted.
Oh.
It was largely influenced by these very powerful psychoanalysts in the mid-20th century. A key figure here was a man named Sandor Rado. He had a massive influence.
And what was his theory?
Rado defined adult homosexuality not as a natural orientation, but, and this is specific, as a phobic avoidance of heterosexuality.
Oh, phobia.
A phobia. Caused by, in his view, inadequate or non-affirming parenting in early childhood.
So the focus shifts. It's no longer about controlling behavior with pain. It's about analyzing trauma and trying to fix some kind of developmental gap.
Precisely. Rado's framework was absolutely crucial because it gave a sophisticated intellectual justification, a sort of quasi-medical model for what later became reparative therapy.
It gave it a veneer of legitimacy.
It did. Practitioners could sincerely believe they were correcting a developmental flaw or a phobia or a relational wound rather than attacking someone's core identity. And this justification allowed the practices to survive even after the APA declassified homosexuality in '73, kept the idea alive that this was a treatable pathology, just, dressed up in new, less physically violent terms.
But today, that entire intellectual house of cards has been completely dismantled. I mean, by virtually every professional medical and psychological organization out there. What's the consensus now?
The consensus is unanimous. It's definitive. Conversion practice is harmful, it's ineffective, and it lacks any basis in evidence.
And this is across the board.
Across the board. It's declared unethical by the American Psychological Association, the American Counseling Association, the National Association of Social Workers, the American Academy of Pediatrics. I mean, the list goes on.
Even the American Medical Association, right? They had endorsed it at one point.
They did, but they reversed their position all the way back in 1994. They concluded that the emotional distress people were feeling came from social stigma, not from their sexual orientation itself. The profession decided that if there's distress, the focus has to be on external discrimination and acceptance, not internal change.
So if we connect this to the bigger picture,
Yeah.
to the standards of medical science and research, what's fundamentally missing from any evidence that proponents might try to cite?
The scientific gold standard, randomized controlled trial, or RCT. That's how you objectively measure if something works.
And for conversion practices?
There are zero, absolutely zero randomized controlled trials supporting its efficacy. The studies that proponents do sometimes cite they're just methodologically flawed.
Oh, so?
They rely almost entirely on retrospective self-reported data. And it's from highly self-selected samples, people who are already deeply committed to a faith-based program. They don't have control groups. They don't have objective measures. They don't meet the standards required to make any kind of robust claim about changing something as fundamental as identity.
But on the other side of that, we have very robust long-term studies that show the exact opposite. They show the damage.
Mm-hmm.
We have one really significant source here from the Multicenter AIDS Cohort Study, or MACS. For our listeners, what is that study and what did it find?
The MACS is one of the most important long-term, large-scale studies out there. It focuses on the health of men who have sex with men, or MSM. It's been tracing participants for decades. This is high-quality longitudinal data.
So they looked at this cohort.
Right. They looked at midlife and older adult MSM in the study and found that 15% of them reported having prior exposure to conversion practices.
15%. And what were the measurable health outcomes for that group?
They were significantly worse off, across the board. The men who had gone through conversion practices were far more likely to experience clinical depressive symptoms. They had above-average levels of internalized homophobia.
And it wasn't just depression.
No. Critically, they had odds of reporting multiple psychosocial conditions. We're talking severe anxiety, substance abuse disorders, other mental health crises that were 2 to 2.5 times higher than their peers who hadn't undergone the practice.
2 to 2.5 times higher. That is powerful evidence. It suggests the practice itself is acting like an external trauma.
Exactly. The researchers on the MACS study concluded that this evidence strongly supports classifying conversion practices not as a treatment, but as a major sexual minority stressor.
A stressor.
Yeah. And you have to consider the MACS participants are generally from pretty well-resourced urban centers, which means the full scope of harm across less resourced, more vulnerable populations it's likely even higher than these statistics suggest. The long-term burden is just crystal clear.
That medical verdict gives us the clinical context, but to really understand the urgency of this legal fight, we have to grasp the human cost. These practices, they're built on a foundation of shame and fear.
They are. The essential message delivered by these practices is just psychologically devastating. It's that being LGBTQ plus is fundamentally wrong,
Yeah.
that the individual has to feel this deep shame and fear until they can successfully change.
And the data on the mental health crises that result,
Mm.
it just confirms this.
It does. The Trevor Project found that LGBTQ youth who were subjected to conversion practices or even just threatened with the possibility, they were more than twice as likely to attempt suicide compared to their peers.
That's a staggering jump. And we have figures that even try to quantify this disaster in purely economic terms. A recent study put a dollar amount on the cost to the U.S. economy.
Yes, and this is a figure that you really need to appreciate the mechanism behind it, not just the total. The practices and the associated lifelong harms, the chronic depression, the substance abuse, the anxiety, the need for long-term care, they cost the U.S. an estimated $9.23 billion annually.
9 billion.
Yeah.
How is a number that astronomical even calculated? It feels almost impossible to attribute that cost directly.
Well, the calculation is complex. It's based on epidemiological models that track the health disparities, from studies like MSCS. And that 9.23 billion, it accounts for several key things. First, you have direct medical costs. Increased hospitalization for suicide attempts, psychiatric ER visits, long-term therapy for complex PTSD. Second, the cost of substance abuse treatment is way higher because survivors are using these coping mechanisms.
And the third piece.
Massive productivity loss. Lost workdays reduce lifetime earnings because of the disabling effects of severe chronic mental illness that was induced by these practices. So it's not just a moral issue, it's a profound public health and economic drain on the entire country.
Let's move from those statistics now to the deeply personal stories that really illustrate this abuse. The sources give us several harrowing accounts, and they often show how licensed professionals use their authority to do this harm. Let's start with Matthew Shirka's story.
Matthew Shirka, who went on to co-found the organization Born Perfect. He was just 16 when he told his parents about his same-sex attraction.
And his parents, they thought they were getting him help.
They did. They took him to licensed therapists who promised a quick cure. They actually framed him as an easy case that would be fixed within 6 weeks. The abuse he went through was wrapped entirely in this veneer of professional authority.
And the treatment, it was deeply manipulative. It was focused on severing emotional bonds.
In what is just an absolutely shocking example of this kind of manipulation, one therapist instructed Matthew to have no contact whatsoever with the female members of his family.
His own mother and sisters.
His mother and his 2 sisters, for 3 full years. The logic they gave him was that his attraction to men was a symptom of having too much female influence. He needed to forge a new masculine identity separate from them.
Unbelievable. And there was more.
Yes. He was also coached to use prescription medication, Viagra, to try and assist intimacy with women. They were trying to literally force a heterosexual response.
That's emotional isolation designed by an authority figure. What was the impact of being forced into that conflict?
Matthew said the psychological damage just felt irreversible. Even when he could physically comply or, perform the role, he knew inside that he wasn't changing. He said, every LGBT person I've ever spoken to knows they never changed.
And that conflict.
That conflict, the deep knowledge of who you are versus the professional demand that you must change, that's what led him directly to intense mental harm and suicidal ideation. He felt fundamentally broken because the fix failed, which only confirmed the therapist's initial message that he was pathologically flawed.
The sources also detailed the story of Lillian Lennon, and her experience shows how these licensed practices are so often tied to institutionalized harm.
Lillian Lennon's experience began at 14. Her Christian parents struggled with her transgender identity, so they sent her to a residential treatment facility in Utah called Island View. She was held there for nearly 2 years.
And this was under the direction of a licensed professional.
Explicitly, the goal was to change her gender identity and the environment. It was incredibly abusive. She was forced to live in a boys' dorm where she faced routine physical, verbal, and sexual harassment from the other boys there.
Which the staff.
The staff reportedly encouraged it. They saw it as part of the treatment.
And the system was designed to punish her for failing to change.
Yes. When the treatment didn't work, meaning when Lillian did not revert to living as a boy, she was punished. She was put in month-long isolation with nothing but a Bible and textbooks. This institutional abuse, administered under the guise of licensed therapy and parental concern, it just shattered her relationship with her parents. It created the very stress factors that lead to these terrible mental health outcomes for trans youth.
And the legal bans we're talking about, they primarily target licensed therapists working with minors.
Yeah.
But Louis' story from the UK, it shows this massive loophole that exists for practices done in religious settings, especially for vulnerable adults.
Louis was 19, so technically an adult. But he was deeply dependent on his evangelical Christian church community. It controlled his housing, his job, his education, everything.
And they found out about a relationship he was in.
Yes, a same-sex relationship was discovered, and he was immediately subjected to conversion practices that fell completely outside the licensed professional world. His experience included exorcisms, forced retreats to healing camps, and mandatory hours-long private prayers of repentance.
And the reasoning they gave him?
He was explicitly told his sexuality was caused by demons that stemmed from childhood trauma, specifically his adoption.
And because he was over 18, the legal system just offered no protection.
That's the critical point. When Louis later went to the police, they told him he was a consenting adult, which meant they couldn't intervene in the coercion or the religious practices. This really highlights that even if the Supreme Court upholds these state bans for licensed therapists, the majority of conversion practices, the ones done by religious leaders, they'll remain untouched.
Finally, we have Jamie's story, which started when they were just 12. And it illustrates the long-term catastrophe of this kind of abuse when it's masquerading as religious doctrine.
Jamie was sent to conversion practices through a religious cult from age 12 to 15. And the core teaching was just merciless. Being homosexual or transgender was an abomination worthy of death.
To a child.
To a child. This instilled a crippling fear and confusion. Jamie felt they were inherently evil and, desperate to survive and fit in, eventually married and had children.
The cost of that suppression must have been tremendous.
It was. Jamie was later diagnosed with bipolar disorder, complex PTSD, and bulimia. They said the impact on their mental health was horrendous, and it was punctuated by multiple suicide attempts.
It's so clear that these practices create immense suffering. So if people know this, why do they seek it out? Or, maybe more accurately, let themselves be coerced into it?
Well, the main reason. It's not simple homophobia. It's the intense internal conflict people feel between their inherent identity, who they are, and their deeply held religious or cultural values.
That conflict creates this distress.
Enormous distress, guilt, shame. Interviewees consistently report feeling incredibly vulnerable and lacking self-confidence when they were approached. They believed they were making a personal choice to align with their faith. But in reality, they were being manipulated and coerced by people in positions of spiritual or familial authority. Pastors, parents, community leaders who just wield immense influence over their lives.
Okay, so the data on the harm is overwhelming. The medical community has completely rejected the practice, so states have acted. They've banned licensed professionals from doing this to minors. But that is what triggered this constitutional showdown.
Yes. The laws crashed directly into the First Amendment. And this is where the legal nuance is just paramount. State bans typically have clear penalties, fines up to $5,000, like in Colorado, or the loss of a professional license.
And the central legal question is,
are these laws regulating professional conduct, which states absolutely have the power to do, even if that conduct involves speaking? Or are they regulating content-based speech, telling a professional what they can say, which triggers the highest level of judicial review, strict scrutiny?
speech versus conduct? And the answer to that question is what fundamentally divides the federal courts. It's how we got this circuit split.
Yeah.
So let's walk through the historical court rulings that created this crisis.
We can start in 2014 with the Ninth Circuit, a case called Pickup v. Brown in California. That court upheld the ban, and they argued forcefully that the law regulated conduct, not speech.
And their reasoning was?
The Ninth Circuit's reasoning was that when a professional is acting in their licensed capacity, the state can regulate harmful, unethical, or non-evidence-based practices. Just like a state can prohibit a doctor from prescribing a toxic drug, even though that involves speaking the drug's name, they can prohibit a therapist from offering a toxic, discredited treatment.
Okay, that makes sense. But then the Third Circuit, around the same time, they reached the same conclusion, but used completely different logic.
They did. In King v. Governor of New Jersey, the Third Circuit also upheld the ban, but they explicitly rejected that blanket conduct argument from the Ninth. They said, look, verbal communication and counseling is protected speech,
Sure.
but they introduced this concept of diminished protection for professional speech. The court held that because these therapists were speaking as state-licensed professionals, their speech rights weren't subject to the highest level of scrutiny. The ban was constitutional because the state had a substantial interest in protecting minors.
So we have two different paths, conduct regulation and diminished professional speech, both leading to the same result, upholding the ban. And then the 11th Circuit just dramatically broke ranks.
The 11th Circuit threw a wrench into everything. This was in 2020, Auto v. City of Boca Raton in Florida. They ruled that local ordinances banning conversion practices were indisputably content-based restrictions on speech.
Because they target the specific message.
Exactly. The content of the message being delivered, that homosexuality can or should be changed. Under that classification, the laws triggered strict scrutiny. The court found the bans failed that test and struck them down, which directly created the circuit split and invalidated bans across Florida, Alabama, and Georgia.
This raises a really important question. Why was the 11th Circuit so convinced these were pure speech restrictions when the other two courts weren't?
Their ruling was heavily influenced by a major Supreme Court precedent from 2018. It was a case called National Institute of Family and Life Advocates, or NIFLA v. Becerra.
And what was that case about?
That case involved a California law that compelled crisis pregnancy centers to provide notices about state services. The Supreme Court applied strict scrutiny, and they refused to allow a lower standard just because the message was being delivered by a professional group.
So NIFLA essentially weakened that whole idea of diminished protection for professional speech.
It did. It eroded the Third Circuit's argument. By refusing to carve out this massive exception for professional speech, the NIFLA ruling paved the way for the 11th Circuit to categorize conversion practice bans as content-based speech restrictions.
So the Supreme Court kind of unintentionally set the stage for this whole legal battle. And now all eyes are on Chiles v. Salazar, the challenge to Colorado's ban. This is forcing them to pick a side.
Exactly. The 10th Circuit had previously affirmed the Colorado ban, siding with the 9th Circuit's conduct argument. But the Supreme Court granting certiorari, that means they have to resolve this split. They have to issue a ruling that dictates whether states nationwide can regulate these licensed harmful practices that rely primarily on speech.
Let's get into the specific claims of the challenger, Kaylee Chiles. She's a licensed professional counselor, and she works with clients who have specific faith-based goals. What's the core of her argument?
Ms. Chiles specializes in trauma, gender dysphoria, and sexuality, often from a Christian perspective. She argues the ban restricts both her free speech and her free exercise of religion rights.
So the free speech claim is?
Her free speech claim is that the law prohibits her from discussing counseling options that align with her client's goals. Goals often centered on living according to a biblical worldview. That might mean reducing or eliminating unwanted same-sex attractions or modifying behaviors to align with their biological sex.
So she's arguing the state is censoring a theological or moral perspective inside a private counseling session.
That's the argument. She claims the law is so vague that it forces her to self-censor. She has to avoid crucial conversations with vulnerable clients who are experiencing this profound internal conflict about their identity and their faith, and the free exercise claim just reinforces that. She argues the ban targets her ability to provide faith-based care.
And what is the state of Colorado's position? How are they defending the ban?
Colorado's defense is rooted in public health and patient protection. They argue the law regulates professional malpractice, a demonstrable standard of care not religious speech.
So it's not about belief, it's about practice.
It's about practice. They stress that the law protects minors from scientifically proven harmful practices, allowing children to develop into their best authentic selves, whatever that identity might be. They maintain the law doesn't favor one identity over another. It only bans the specific, discredited, harmful attempt to change that identity.
The stakes here are just immense, especially for the regulatory power of states. What happens if the Supreme Court agrees with Chiles?
If the Supreme Court rules the ban is an unconstitutional restriction on professional speech, it means that 11th Circuit auto precedent holds sway, and that would immediately risk invalidating state and local conversion practice bans all across the country.
But the impact could be much broader than just this topic.
Oh, much broader. It could fundamentally weaken the ability of states to regulate any aspect of licensed healthcare. We're talking about laws regulating reproductive health, laws governing gender-affirming care for minors. If those regulations can be successfully characterized as restricting a clinician's protected speech or religious exercise, it would be a monumental shift in state authority over public health.
Okay, so we've established the central legal vulnerability here is the First Amendment challenge. But as Louis' story showed us, the vast majority of these practices are not happening in a licensed therapist's office.
No, they're happening in religious communities, in camps, through unlicensed mentors.
So how do the current state bans fail to address that wider ecosystem of harm?
Well, that's the gaping hole in the current regulation. Because they target licensed professionals, the bans just. They fail to prevent the primary perpetrators, clergy, religious organizations, unlicensed counselors, from operating. These practices often take place entirely within a religious context, where the relationship is spiritual, not legally professional. So the bans, while symbolically powerful, have very limited material reach.
So given that this current approach is running into constitutional problems, what are some alternative legal strategies that might actually reach those unlicensed providers and withstand scrutiny?
There are a few creative strategies legal scholars are looking at. One is to just flip the target. Instead of regulating the speech of licensed professionals, states could prohibit conversion practices by regulating only those who perform it without a license.
Applying penalties for practicing therapy without credentials.
Exactly. And what about leveraging existing ethics standards? We've seen this in states like Indiana and Louisiana. How does that approach avoid the constitutional trap?
This is a really effective, more legally robust strategy. States like Indiana and Louisiana haven't passed these explicit new bans. Instead, they rely on existing laws that govern professional ethics and misconduct.
So the licensing boards step in.
The licensing boards are empowered to discipline practitioners who violate the standard of care by administering demonstrably harmful, non-evidence-based treatments.
So instead of saying you can't talk about changing sexual orientation, which is content-based,
The board says you violated the core duty to do no harm by providing a treatment that every major medical body agrees is malpractice.
precisely, by framing the enforcement as a regulation of professional misconduct, they focus on the conduct of providing a harmful service. And that avoids the strict scrutiny triggered by content-based speech restrictions. This approach might prove far more resilient, regardless of how the Supreme Court rules in Chiles.
Moving past the strict legal side of it, these bans still serve a vital purpose, which our sources call the expressive function. What's the social and cultural message these laws send?
Well, this is what's so fascinating, the social engineering aspect. These laws are a profound public statement that shapes social norms. Dr. Jack Drescher, a prominent psychiatrist, noted that the bans are essentially a public statement of acceptance of LGBTQ+ people.
It's the state taking a stand.
It is. When a state legislature bans the practice, they're reinforcing the scientific and ethical reality that these identities are not mental disorders and cannot be changed. This public stance acts as a cultural deterrent. It signals that anyone offering a cure is operating fundamentally outside the mainstream of science and ethics.
And that expressive function allows advocacy groups to strategically push back against these long-standing negative narratives.
Absolutely. The bans are a powerful tool for promoting two key themes: the immutability of identity and the need for child protection. For decades, opponents of LGBTQ+ rights argued that these identities were a choice and that gay or trans people were a danger to children.
And the bans flip that narrative.
They completely flip it. The state becomes the protector of the child's authentic self, and the danger is identified as the practitioner of conversion practices. So the law achieves a significant cultural victory, even if the legal regulation itself is imperfect.
And this trend isn't just in the U.S. We're seeing a major international push on this.
We are. The international movement is robust, and it's often more aggressive than U.S. state law, largely because of different constitutional constraints on free speech.
Like in Canada.
Canada took the most sweeping action. They implemented a nationwide ban in January 2022. And crucially, the Canadian law criminalizes conversion practices for both adults and minors under their federal criminal code. It's illegal to provide, promote, or profit from the practice.
That's a criminal approach, which is very different from what we're debating here.
Mm-hmm.
Germany provides an interesting comparison, though, showing how U.S.-style free speech concerns can influence this legislation internationally.
Germany offers a key insight, yeah. They banned conversion practices for minors under 18 back in 2020, But for adults, the ban only applies if consent was secured by force, fraud, or pressure.
And they forbid advertising.
They do, and the German health minister, Jens Spahn, said explicitly that they limited the scope to avoid making the law vulnerable to legal challenge, meaning they recognize that an absolute ban on consenting adults, even if it's harmful, might not survive scrutiny based on German free speech protections. And that's a very familiar parallel to the conflict here.
Finally, how are international human rights bodies weighing in on this? Do they see this as just malpractice, or is it something more severe?
International human rights bodies classify this practice extremely seriously. The UN Committee Against Torture, or CAT, has indicated that all conversion practices amount to, at minimum, degrading treatment, which is an absolute prohibition under human rights law.
And that applies regardless of consent.
Regardless of whether the victim is a minor or an adult and whether the practice was forcible or allegedly non-forcible.
And why do they emphasize that the ban has to cover even non-forcible forms and religious counselors?
Because they recognize the inherent power imbalance and the dehumanizing nature of the goal itself. They conclude the practice is intrinsically abusive and violates a person's fundamental right to dignity. That's why they argue the legal bans should be comprehensive, covering all potential providers, religious counselors included, and that individual consent carries very little legal weight when the practice itself is inherently harmful. Brazil actually led the way on this, banning psychologists from offering it back in 1999.
So, we've navigated the devastating human costs, the unequivocal scientific rejection, and these thorny constitutional questions. The story of conversion practices really is a conflict between medical science, personal dignity, and constitutional law.
The central conflict.
Yeah.
It remains entirely focused on that legal classification. The future of state conversion practice bans across the U.S. hinges on whether the Supreme Court accepts the argument that these practices are professional misconduct and harm that states can regulate, or whether they accept the argument that restricting a clinician's ability to talk to a client is a protected, content-based restriction on speech and religious freedom.
And the outcome of Chiles v. Salazar is going to dictate the limits of public health regulation for decades.
It is. That tension, the gap between what we know to be true about human health and what the First Amendment permits governments to regulate, is just immense.
It really forces us to confront a fundamental question about the boundaries of state power.
It does. If a professional practice has been universally rejected by every major medical and psychiatric organization, deemed ineffective, and proven to cause profound mental and economic devastation, at what point does a constitutional right to speech on the part of the clinician yield to the state's fundamental obligation to regulate a licensed profession for the protection of vulnerable minors? That line, wherever the Supreme Court draws it, will define not just the fate of these bans, but the balance of religious liberty, free expression, and public health in the modern era.